Okay, welcome everybody. We're right at a little after 12. I'm Dale Caldwell, a professor and executive director of the Rothman Institute of Innovation and Entrepreneurship. We have some more wonderful guests, Nicole Tracy and Ursula H from Laddy, Clark, and Ryan, attorneys at law. As always, I'm going to kick it off with a discussion of who the Rothman Institute is and some of our programs. And then we're going to go through some slides, but we really want, as we always say, as many questions as possible. Our hope is that this will be an informative session. Human resource issues are more important than ever, given the pandemic and what's gone on this last year. But who is the Fairleigh Dickinson University Rothman Institute of Innovation and Entrepreneurship? Our mission is to support, promote, and research entrepreneurship with a special focus on family and veteran businesses. We really work on all entrepreneurs, but we have become one of the leading programs when it comes to family businesses. Our programs include our Family Business Alliance that includes everything from consulting to special speakers to a coaching component of it. We have student programs to encourage entrepreneurship. We've been doing that for 30 years. Our Veterans Launching Ventures program helps veterans and their family members develop business plans and develop a business. We've been writing a lot of articles, research, and policy around entrepreneurship and the importance of entrepreneurship. We do strategic planning with our clients. We're doing more and more urban business support to really help businesses in urban communities. We do leadership, sales, and diversity training. And one of the things that we're starting to do now are expand executive certification programs. So we're thinking about doing everything from SHRM executive programs to CFP programs to some other programs. Our sponsors are really the foundation of who we are. We wouldn't exist without TD Bank Charitable Foundation, Provident Bank, SunTrust, Commerce and Industry Association of New Jersey. Tony Russo, I think, may join us, the president, a little later. And I'll make sure to let him in. One of the important things to remember about entrepreneurship, especially family business entrepreneurship, it's more important than ever. It's really key to, I just wrote an article about King, to bridging the political divide. We have two sides on this country. The one thing that people can agree on is how important entrepreneurship is and family business is to the American economy. Public policy, therefore, must support entrepreneurship, and we're pushing for something we call the establishment of entrepreneur zones, where investments can go into urban communities to support the growth of entrepreneurship. One of the things we're most proud is creating the Family Business Week. And so every fourth week in October, we are encouraging people to spend the whole week supporting family businesses. We want you to do that throughout the year. But family businesses need our help more than ever, because during the pandemic, when a family restaurant or others is closed, every member of the family is unemployed. And so they suffer more than a lot of other businesses. It's important to remember that when we're going out to dinner on a Friday night tonight, think about supporting family businesses where you can. I have a TV show called Family Business World, and the website's familybusinessworld.com. You can see some of the old shows. It appears on rvntv.tv every Thursday at 10 a.m. and 8 p.m. We're really trying to promote, again, family businesses. Obviously, our program today, the Family Business Fridays, and our Veterans Launching Ventures program, which we're so very proud of, has become a truly national program with participants from 11 different states, 2 countries. And what we do is really work closely with veterans or immediate family members of veterans to develop business plans to help them grow their business. And as you know, many veterans aren't doing well. They're suffering and they're struggling, and we're trying to do our part to really support them. And we encourage all of you to go to our Rothman Institute of Entrepreneurship channel on YouTube. This video, as well as our other videos, are there. So it's an incredible resource of information, no matter what kind of business you have or what kind of information you're looking for. So we hope you will look at that. And finally, our Family Business of the Year Awards. We had our 28th awards, where Laura Maschtaler and Black Swan Espresso won our new Family Business of the Year. We had the wonderful Makula Contracting was our under 10 million winners. And Norwalt Design was our over 10 million winner. So next October, we're going to have that. So with no further ado, I'm going to introduce Ursula H and Nicole Tracy, and I am going to stop sharing these slides and share their slides. And it's good to see we have some questions already. So.
Great. Thank you. We're excited to be here. I'm Ursula. Nicole is here also. And whenever you guys have questions, please feel free to use the chat or the screen, and we'll be happy to answer them as we go. What we have is just a short PowerPoint presentation that just goes through some of the overhead laws, and that'll be available for you guys. We'll get a PDF out to Dale later today in case anyone wants that information. But Nicole and I both are within our employment and law practices group at Laddy, Ryan. We're a law firm in Sparta. And Nicole and I have been practicing in employment law for quite some time. We represent both employers and employees. We've been very busy during this COVID time while we're all trying to figure out how you handle leave and paying leave and people who don't want to come back, people who are afraid to come back, and how to deal with that. So just from a really broad perspective, there is alphabet soup clearly in New Jersey when it comes to employment law. So state statutes we deal with are the LAD, the Law Against Discrimination. We've got SEPA, which is the Conscientious Employee Protection Act. SEPA is the whistleblower law that says you can't be retaliated against for voicing a concern of a violation of a law, rule, regulation, or policy. SEPA is big right now, of course, for PPP, right? If someone says someone isn't wearing a mask, do you have hand sanitizer? All those questions. Do we need to be gloves? Are we filing a complaint with OSHA? So SEPA is something we're seeing more of. What is a little unique about SEPA, there's a 1-year statute of limitations. New Jersey Law Against Discrimination is one of the most comprehensive through the country, basically saying you can't discriminate based upon any protected classes. And in New Jersey, anyone can fit in as a protected class. And we'll go over that briefly.
So Ursula, again, I'm going to ask questions as I go.
Sure.
Because, we bring these experts on and they know so much and they go so quickly sometimes that I ask the dumb questions. So if we don't, so it's 1 year. So explain a little more about that. So if someone gets COVID or something, they only have a year to file, or how does that work?
So it's never black and white, right? Because that wouldn't keep me employed. It's always gray. So it's from when you know or should know about a violation, right?
Right.
So say yesterday you complained to your manager that they didn't have the gloves in place that you thought you needed in order to have a safe workplace. You have 1 year from that time when you knew or should have known to make a complaint. So it's pretty simple if you filed a complaint. Yeah. However, if your employer didn't post a SEPA notice, which is required, if they didn't provide you with the notice upon hiring, then you can say, oh, well, I didn't know about that. I was upset about it. I talked to my coworkers about it, but I didn't know who to complain to. So that can extend your statute of limitation period going forward. It's always tricky, but if you filed a complaint, it's 1 year from, but if you didn't know about it, that can extend the statute of limitations.
And one question, I know you're not insurance agents. Does insurance cover that? So if someone's liable and you sue them, does insurance cover that? Or how can small businesses protect themselves?
So one of the new things, one of the first things I ask now when I am consulting with a small business owner is, do you have EPLI, Employment Practices Liability Insurance? Okay. Because no matter what we do, no matter how many policies, you have a handbook, you have the training in place, there's nothing you can do to stop an employee from suing you, right? Okay. And unfortunately, once that complaint is filed, you're looking at tens of thousands of dollars just to get to mediation, right? So once that complaint is filed, you have to file an answer, you have to go through the discovery, even if it's a terrible claim, even if you're going to get it out. When you're going to get it out is possibly at the beginning with a motion to dismiss, highly unlikely. So it's a motion for summary judgment that takes a long time to get to. So that employment practices liability insurance in general protects against law against discrimination, protects against SEPA, protects against all those employment claims. And it's something definitely all small employers should look into.
Okay, so say the name of the insurance again. What is it? Employee?
EPLI, Employment Practices Liability Insurance. And that's something to check with your broker for. The cost difference is huge. I've had clients who come in and it's crazy, but it depends always on your deductible and what your past history is, of course, too.
Excellent. Good. Okay, go ahead. Sorry to interrupt you, but I want to make sure we cover that for the audience.
Oh, no, please, anytime. Yeah, so something you should consider. And so the new things we're looking at now are, of course, New Jersey's Family Leave Act and the Earned Sick Leave Law. So in New Jersey now, for every 30 hours worked, you're earning 1 hour of sick pay. A lot of us already had that, but if you didn't, you're now being required to provide that paid sick leave. And that's not something we weren't necessarily going to go into with detail, but if there's questions, just again, things to remember that are out there. New Jersey Family Leave Act is different in that what it does is provide for 12 weeks of job protection, not pay, but job protection. And are you reading that question there carefully?
Yeah, I'm trying to see what make sure we're covering that. But yeah,
Oh,
go
and then
ahead.
we can go to the next slide if that's okay.
Okay, next slide. Okay, perfect.
We've also got to deal with federal statutes. And again, New Jersey, because our laws are so strict, we typically look at the New Jersey law, but just so you know, Title VII Civil Rights Act, that's where our law against discrimination in New Jersey is what we look to because it is strict, more strict. Age Discrimination and Employment Act. It used to be 40. If you were over 40 and replaced by someone under 40, that could be an argument for age discrimination. We now see reverse age discrimination where people think they're being discriminated against because they're younger, and that 40 has gotten very gray. Where if it's 38, if it's 42, so that's not so clear, but there's definitely an age component to that also.
Ursula, let me step, because this age discrimination, I know so many people, who, if you're over 50 or over 55, it's almost impossible to get an interview or get a job. And again, that's not, you can't sue for discrimination, but is there any protections of, against that from an employee standpoint? Because I run into that all the time with people.
Yeah, so New Jersey is an at-will state, which means anyone can be terminated for any reason or no reason, as long as it's not a discriminatory reason. So I know a lot of people, when they're terminated, they'll get, the severance package, and you'll get the help of a benefit plan or help of a consultant and a recruiter to help you moving along, which unfortunately, you're right. If people are of a certain age, it seems that they're having trouble. But because New Jersey's at will, as long as, again, it's not for discriminatory reason, there's no protection there. Where we're also seeing the age come up right now is for COVID, right? At the beginning, it was anyone over 65 in the workplace. How do we deal with that? So one of my favorite acronyms in employment law is no good deed goes unpunished, right? So you as a small business owner say, you know what? Shirley's over 60. I don't want her coming into work. She's in that group that she could get ill. So if you do that based upon her age alone, you're opening yourself up to an age discrimination claim. And because of COVID, it's a little bit, everything's changing, right? This time next year, we're going to have whole new discussions. But in general, you don't want to make employment decisions based upon an employee's age.
And one final question. So if I'm an employer and I have 30 employees and all of them are in their 20s, am I at risk of age discrimination that I've interviewed people, but I don't hire anybody over 40? Is that a risk for an employer or not?
Sure. So I think when someone could get a hold of that information, they could try to argue, right, that, yeah, look at all these people that applied. They'd have to get the information and show, as long as there was older people who did apply for the position and they weren't provided. And what are the chances statistically, right, that only within that age group? But then it's proving the case, proving that because of age, those people weren't provided with the same employment opportunities.
Okay, great. Thanks.
ADA, the Americans with Disabilities Act, is something, again, protected by the law against discrimination that is very much changing daily now. We were never allowed to ask employees about their medical conditions until March of this year, right? All of a sudden, you could ask what their temperature was. You could take their temperature when they came to work. You could ask about their illness. Before it was, okay, sick, go, right? We don't want to know about it. We don't want to know because we don't want to make decisions based upon an employee's disability or their perceived disability, right? So if someone comes in, you think they're ill and you send them home, that used to not be a big deal. We didn't ask further as to why. Now, because of what's going on with COVID, we do want to know more. We want to know, is there anyone at home who's ill? So Americans with Disabilities Act, you just want to make sure what we're doing is consistent, and you want to make sure you're enforcing your policies consistently with all of your employees so you're not opening yourself up to a disability discrimination claim. So what Nicole is going to get to eventually here is the Families First Coronavirus Response Act. So again, our alphabet soup here, FERCA. Basically, there's two important things for FERCA. One is the Emergency Paid Sick Leave Act, and one is the Emergency Family and Medical Leave Expansion Act. What's different is the New Jersey Family Leave Act applies to 35 employees or less. FMLA was 50 or more. Now, Families First Coronavirus Response Act, anyone with less than 500 employees. So now people who didn't have to worry about FMLA have to worry about paying employees who are taking leave for COVID. So that's the game changer here for our small employers. If we can get to our next one, please. Next slide.
Okay.
So law against discrimination, again, why it matters is it applies to all aspects of your employment-employee relationship. So when you're hiring people, when you're interviewing, when you're promoting, when you're discharging, even as simple as where you're placing an employee, because now people can charge discrimination based upon the fact that they're by a window, they're on the third floor, whatever it is. So you want to make sure you understand that. You want not discriminating against employees based upon anything that could be protected by the law against discrimination. And next, please.
Yeah, okay, so what is the legal definition of discrimination for those?
So discrimination is treating someone differently based upon a protected category. And if you slip to the next slide real quickly,
Yep.
when we talk about treating them differently, that's that previous slide, right? You're treating them differently in their hiring, in their whatever, anything related to their employment, based upon any one of this protected categories. Now we call it an adverse employment action, right? If someone suffers an adverse employment action due to being one of these protected categories, that's what we classify as discrimination, a legal discrimination under these protected categories. So remember I said earlier, everyone's covered in New Jersey, everyone's a certain race, everyone's a certain sex, everyone's a certain age, right? So in New Jersey, your race can be a protected category, your creed, your color, your national origin, pregnancy, familial status, marital status, so much that if you're treated differently by your company because you've had a divorce, that might be an issue. Breastfeeding is new within the last couple of years. And then the big ones here, again, during COVID age, is the disability or perceived disability. Genetic information, that we used to not worry about. But now when you bring new employees on board, and if they file out insurance information, if they fill out, sorry, and they're telling you they have a family history of cancer, you want to make sure you're not making any employment decisions based upon that, because now you're looking at genetic information. Again, the realm of what's protected in New Jersey is huge. The take home from that is make sure if you're making employment decisions, document them. It's not because of their genetic information. It's the fact that they were a terrible performer. It's the fact that they were late to work 25 times. Whatever it is, make sure you're documenting that so that your employees can't argue it was one of these protected categories that led to their termination or discipline at work.
Next slide.
All right. Yes, please. So next, so this is a great scenario that's put up by the New Jersey Department of Labor, which is a little small, I apologize. But you can, if you just Google New Jersey government labor, you'll see on the bottom left there. What it does is shows you if you have an employee who comes to work, if they're sick, under what scenario, what type of leave is provided. And these are the things that are very difficult for you guys all today's, with all the different changes going on. The first one there is FMLA. So FMLA. Second is if an employee gets paid sick leave, then it's earned sick leave, then unemployment, and then family leave insurance. So when your employee comes to you and say they can't come to work because they are afraid of going to work for COVID, because someone at home has COVID, this is a great chart to look to figure what leave is available to them. One thing you want to be careful of is when your employees are asking you what leave is available, when it's unemployment or when it's any of the programs provided for by the state, be clear that that's for the state to decide, not you. You'll fill out the required paperwork, but it's up for the state to decide if you're going to be granted unemployment or not.
Okay. The Ursula, just there's an Ellen McSpadden said, I'll be hiring for the first time soon and intend to pay therapists on a fee-for-service basis. Do I just figure out the equivalent hourly rate and use that for earned sick leave?
Basically, yeah. So you're going to want to go to the Jersey Department of Labor again website that'll have for you the details about what's required. But for your paid sick leave, it's going to be, was it paid sick leave? I'm sorry.
Yeah, paid sick leave.
Yeah. So for every 30 hours, they're going to get one. You're going to go ahead and have a look back period. And if they're new, you're going to just average what their salary is going to be. And what's important is it's a max of 40 hours a year. And you as an employer can decide, do you want to pay that at the end of the year or do you want to carry it over? Okay. If you pay it, everyone's going to take it, because the only reason you would carry it over as an employee is if you want to take that vacation in January, because you can never use more than 40 hours a year. Right. So again, it's just the carryover. If you have a December year, in January, you'd have those hours available that you ordinarily wouldn't. But if you're going to pay it out, your employees are going to be entitled to some additional pay there. So yeah, what you want to do is look at their pay and average out to figure out what they're due.
And if Nicole, before you get speaking, if you could put in there your email address, and contact information. So if anybody wants to call you, they have follow-up questions, I want to make sure they can call the law firm. So that would be helpful.
In the chat box?
Yeah, in the chat box, if you could, that'd be wonderful. Next slide.
Sure. I'll put it, Nicole, if you want to. I know you want to do this part.
Oh, sure.
Okay.
Okay, good. Perfect.
So COVID-19 has presented some major challenges for employers and for small businesses, because the leave laws that were created by the Families First Coronavirus Response Act, which I'll call FERCA, apply to all employers with 500 or fewer employees. So it used to be that if you're an employer, but you don't have 50 or more employees, FMLA didn't apply to you. And if you are an employer and you don't have 30 or more employees, the NJFLA, which Ursula discussed, does not apply to you. And that remains the case for unpaid leave, but FERCA created 2 new leave laws that apply to all employers with 500 or fewer employees. And the first is the Emergency Paid Sick Leave Act, which I'll talk more about. And the second is the Expanded Family and Medical Leave Act. So if you're that employer that has fewer than 50 employees, this applies to you, the Expanded Family and Medical Leave Act, and it's paid leave. These are both types of paid leave programs. You also want to make sure you're familiar with the FMLA and the NJFLA, which Ursula went through, and then the New Jersey Earned Sick Leave Law. But we can move on to the next slide, and I'll get into more details about.
Yeah, just in general, the small businesses are struggling. Why would they put this burden on that? I know you can't answer that, but I don't know if you have any insight into. It seems like of all the times they wouldn't do that.
That's what a lot of small employers are saying. It's a very burdensome requirement, and in many cases, in the event that employers are required to provide this type of leave and they don't have a large number of employees, it can be crippling. And there is a small business exception, which I'll talk about, but it's very hard to apply and it needs to be sparsely used. So I'll go through that. I'm just going to step everybody through the Emergency Family and Medical Leave Expansion Act, which I'll call the EFMLEA, and then the Emergency Paid Sick Leave Act. So the EFMLEA is basically an expansion of FMLA. Now, as everybody knows, basic stuff, the FMLA provides 12 weeks of unpaid leave for an employee's serious health condition or for them to take care of a family member who is ill. The Emergency Family and Medical Leave Expansion Act is paid leave. It's 12 weeks total. 10 of the weeks are paid, and employees are paid 2/3 of their pay during 10 of the 12 weeks of leave under the EFMLEA. Under the Emergency Paid Sick Leave Act, employers are required to provide up to 80 hours of paid sick leave to full-time employees, or the equivalent of 2 weeks worth of hours to part-time employees for 6 qualifying reasons. If the employee meets one of 6 qualifying reasons, they qualify for leave under the EPSLA. If they qualify for leave under the first 3 reasons, they get full pay for the 2 weeks. And if it's for the remaining 3 reasons, which I'll go into, they get 2/3 pay. In order to take leave under either of those laws, employees must be unable to work or telework. So it's an employee that truly cannot be present at work. If they're working from home and they're able to continue working, they won't qualify. But if they're ill and they can't do it, assuming they meet one of the qualifying reasons, the employer needs to provide that leave.
Interesting. Okay. Good.
So we'll go on to the next slide and I'll talk a bit about each law in more detail. So the EFMLEA is the expansion of the FMLA, and it applies only in one instance. It's when the employee is unable to work or telework due to a need to care for their child who's under 18 years of age if the child's school or place of care has been closed, or if the child's care provider is unavailable due to a public health emergency regarding COVID-19 as declared by a federal, state, or local authority. So what does that mean? If the state has shut down a school and children are learning remotely, and that parent is the only person available, an employee is a parent, and they are the only person available to care for their child, they qualify for EFMLEA leave. If the child's daycare is closed for COVID-related reasons and it's pursuant to a state order, directive, or some other type of law, that parent, if they're your employee, will qualify for EFMLEA leave. This also applies to a son or daughter. It's not just a son or daughter under 18 years of age or child under 18 years of age. It's also if an employee has a disabled adult child and their care facility is closed due to COVID-19. We get a lot of questions from employer clients saying, well, my employee has COVID. Does this mean they get 12 weeks of leave, 10 of which are paid under the EFMLEA? The answer is no. And again, it's only if they have a child and their school or daycare is closed, or an adult child who's disabled and their care program is closed. So it's a very limited window. And this is at 2/3 pay. On the next slide, I talk about the Emergency Paid Sick Leave Act and the qualifying reasons. And it's important to know what these are so you know if your employee even meets the criteria, right? So the first reason for an employee to qualify for leave under the Emergency Paid Sick Leave Act is when they are subject to a federal, state, or local quarantine or isolation order related to COVID-19. If they cannot come to work, if they are ill, that is key. And this is also when the state issues an order and they shut something down. If that employee cannot get to work, that's the first qualifying reason. The second, and really the most common one, is when an employee is advised by their healthcare provider to self-quarantine due to COVID-19 concerns. right? So that employee may come to work, or they may start to get symptoms of a fever. They may be sent home. They go to the doctor and they get a COVID test. Sometimes the test takes 3 days. That doctor may say you need to self-quarantine until you get the results of your test. And that employee will then qualify for EPSLA leave under the second qualifying reason listed here. The third qualifying reason is when an employee is experiencing COVID-19 symptoms and they then seek a medical diagnosis. So it's not just the time that they're advised to self-quarantine by the doctor, it's the time that they actually go to the doctor, make the appointment, go to the appointment, and are seeking that medical diagnosis from their doctor. And these first, second, and third reasons, under the Emergency Paid Sick Leave Act, if an employee qualifies, they get their full salary for up to 2 weeks worth of work. So employees are considered full-time if they work 40 hours a week under the EPSLA or more. And if they work fewer than 40 hours a week, they're considered part-time. And if an employee qualifies for leave for any of these reasons, the way you calculate what leave the employee gets is if they're full-time and they work 40 hours a week, it's easy. They get a max of 80 hours of leave. If they're part-time, you look at what they work per week, average it over 2 weeks, and give them that. So if they work 35 hours a week, they get 70 hours of paid leave under the EPSLA. So again, these are the first 3 qualifying reasons. And when we move to the next slide, I'll talk about the 4th, 5th, and 6th qualifying reasons, which I think we may have skipped a slide there. Was there one before that?
No.
Okay, well, we should have had a slide on there with the 4th, 5th, and 6th qualifying reasons are essentially when an employee's child's school or daycare is closed, or they're advised not to come to work because of a quarantine order. And you need to understand that if an employee, if their child's school or daycare is closed, they only don't qualify for the EFMLEA leave, which is the 12 weeks. They get 2 weeks of paid leave under the EFMLEA, or 2 weeks of leave, under the Emergency Paid Sick Leave Act. Okay. Another qualifying reason for leave, which is the 5th qualifying reason, is when an employee's family member is sick, has COVID-19, and they need to be cared for, and that employee needs to stay home and take care of that person. For those 2 reasons, the school or daycare being closed due to COVID-19 or taking care of a family member, that employee gets 2/3 pay for 2 weeks under the EPSLA. So it's just important to know those qualifying reasons. If it pertains to the employee, him or herself, and their need for care, seeking a medical diagnosis, waiting, quarantining, that's 1 through 3 qualifying reasons. They get full pay. If it pertains to the school or daycare being closed, or to an employee caring for a sick family member who's quarantined or has COVID-19, that falls under the second 3 qualifying reasons. And for those reasons, they get 2/3 pay, just like under the EFMLEA.
Wonderful. I'll go to the next slide.
Yes.
Hold on a sec. There you go.
All right, so I just want to really just reiterate these different laws here, just so we have a refresher. So the FMLA is 12 weeks of unpaid leave for an employee when they need to take leave for their own serious health condition. NJFLA is only in New Jersey, and it's 12 weeks of unpaid leave to care for an employee to care for their family member with a serious health condition, and also to birth and bond with a child, but that's not really relevant to the COVID-19 discussion. And these apply, again, FMLA only to employers with 50 or more employees, NJFLA only to employers with 30 or more employees. But it's just important to keep in mind that with COVID-related concerns, if you're an employer and you have 500 or fewer employees, the EFMLEA and the EPSLA do apply to you. I want to note quickly before we move on to anything else, there are some exceptions, because you asked me, what do small businesses do? Mm-hmm. Do they have any way of seeking recourse here, protecting themselves? Yes, there is a small business exception, and that applies to the Emergency Paid Sick Leave Act. And if a small business can show that granting an employee paid sick leave would essentially cripple their business, would make it so they couldn't even operate at minimal capacity and threaten the viability of their business, they can invoke the small business exception and deny that employee paid leave under the EPSLA. It's rarely legitimate. You really have to be able to show that it would harm your business. And I cannot emphasize enough here, if you are a small employer and denying that leave based on that small employer exception or small business exception, you have to document the basis for that. I would have financials. I would have in that employee's personnel file the basis for the denial of the leave. And as with anything you do in the employment context, when you're making a decision about one employee, make sure you apply the same reasoning and uniformly apply your policies to every single employee. So no one can say, wait a minute, they denied me EPSLA leave and they invoked this exception, but they gave it to somebody else. And we're both key players at the company. It's really important that you approach that uniformly and deal with it the same. The other exception that's in place is there's one, it's called the healthcare provider and emergency responder exception. And so for our public employer clients, municipalities, when someone is sick under the EPSLA or they need to care for someone, but they are, say, a firefighter, they are a police officer, they are someone who is vital to responding to emergencies for a public entity, that person can be denied paid EPSLA leave on that basis. And that's really important to keep in mind. The same leave can also be denied to healthcare providers. And the reason for that is the government is seeking to ensure that all healthcare providers are available, working, and there's no issues with short staffing there. And obviously you want to use your discretion here. If an employee has COVID-19, if they've been exposed to somebody with COVID-19 and they qualify for leave, of course you want to consider granting it because you want to keep your employees safe and you want to minimize any direct threat that your employees will have of contracting COVID-19. So it's important to keep that in mind, but it's also key to know that you have these options if you're an employer with under 50 employees and if you employ emergency responders and healthcare providers. So just keep that in mind.
So Nicole, before we move on, let's use an example. I'm a restaurant. I'm a family-owned restaurant, and we're operating at 25% capacity. Any employee that gets leave is going to negatively impact the business. Is that sufficient, or even though you're not making a profit to begin with? So any activity like that is going to hurt the business. Is that sufficient, or you have to do even more than that?
You have to do more than that. You have to show that it will jeopardize the viability of your business. You have to show that if that person for 2 weeks does not come to work, your restaurant could close down. It's a high threshold, and employers are being told to use it sparsely because this is something that's strict. It's being strictly enforced by the DOL. And at this point, it's interesting because there's no obligation to submit that proof and that documentation to the DOL, but we don't know where they'll go with this and how long they'll extend this for. So I would really say, to the extent that you can grant the leave for that employee and none of the exceptions are met, I would grant that leave. But if you can document it, and that employee is a key employee, it's your chef.
It's your chef.
You have another chef, right? And your restaurant is going to have to shut down for 2 weeks, and shutting down for 2 weeks will make the restaurant close. Yeah, you can deny that leave, but you have to be in a really desperate position to do that.
Yeah. Okay.
Sure.
Great.
Nicole, before you move on, there was just one question here about when someone asked if everyone in their company is working remotely, can there still be a claim related to COVID for PPE, the protective equipment? So maybe you just want to touch on that Executive Order 192 quickly.
Sure. So the state, actually, Governor Murphy just issued Executive Order 192, and it actually mandates workplace coronavirus safety measures. And one of the mandates in the executive order is personal protective equipment, or PPE. And the executive order specifically says that employers must require all employees, customers, visitors, and other individuals entering the worksite, so anyone coming onto the premises, to wear cloth or disposable face masks while on the premises, and that has to be in accordance with the Centers for Disease Control, or the CDC guidelines. And that's the only exception is when the person on the worksite is under 2 years old, which is very rare, or when it's really impracticable for an individual to wear a face mask, right? So if they're eating or drinking, sitting in their cubicle and kind of sequestered away from everybody else, or where they can't perform their job while wearing a mask, which again is rare, there can be an exception. But that's when you're on the actual work site, right? So if your employer requires you to come to work, you have to wear a mask. They have to provide masks, right? But if you're working from home, those same requirements don't apply because you're not coming into the work environment. But employers do need to make sure they follow this executive order, which also requires certain social distancing protocols, sanitation measures, hand hygiene protocols, routine disinfection of highly touched areas, mandatory health screenings every day at the beginning of every shift of all employees, immediate removal of sick employees from the workplace, immediate notification of COVID-19 exposure, and then disinfection subsequent to that exposure. These are all outlined in their laws now. And the reason it's significant to know about this executive order is before it was guidance issued by the CDC. Now it's an executive order, and there's a complaint mechanism in place for employees when their employers do not adhere to these requirements. So when you're working from home, your employer doesn't have to give you a mask, right? But if you go to work and you wear a mask and your employer is not requiring other employees to do so, you can file a complaint with the State Department of Labor, and there are fines and penalties associated with that should there be a finding that there was non-compliance with this executive order. So I encourage everyone, we have an e-alert on our website about Executive Order 192. We can send the link out when we circulate the PDF of the PowerPoint, and it outlines those requirements. So I strongly urge you to read that and to read the executive order, because it really is being strictly enforced at this point.
And there's no carve out for 10 or fewer employees or anything?
No, this is for every single employer, every single workplace. And it doesn't just apply to main headquarters. It's a satellite office. If you have one person and they have to come to work, it doesn't matter. The same requirements apply. It's very strict.
Wow. Yeah. Ursula, were you going to say something?
I was just going to move on to the other questions before she moves on to the next one. There's another question about an employee who only works when work's available. So it sounds like a sporadic part-time employee. And they get sick with COVID when there's not a time, when there's no work for them. So is there any potential exposure there? So I guess the question is, essentially you have someone who's very part-time, they get COVID, so they're out of work when they wouldn't have regularly scheduled work. What do we do in that circumstance? And in that, I think the issue is you'd have to document that they aren't available for work at that time. And then you can refer them to unemployment. And you can tell them, that, okay, I understand you have COVID, but at this point in time, we have no work for you anyway. So therefore, there's nothing for you to do. But again, I think you need to be able to document that, no, they wouldn't regularly be working at this time, and refer them to the agencies, unemployment, sick leave, whatever it is that they have available. The next question, Nicole, before you move on, is can you refuse to hire an employee because he or she has COVID?
You can refuse to permit that employee on the work site until they have a negative test result and until they are cleared by their doctor, but you cannot refuse to hire an employee on the basis that they have COVID-19.
So whenever you take an adverse employment action, we'll call it, which is where you refuse to hire, refuse to promote, whatever it may be, you want to make sure you're documenting the reasons, right? So if this is an employee who's come in and you're choosing not to hire them because they have COVID, that's probably not the answer. That would get you in trouble, right? But if you have 50 applicants and you've interviewed all 50 applicants, there might be 15 different reasons you're choosing the one applicant over this one, right? So the key is to document the reason you chose them, and don't make it because of COVID. Make it because of their lack of experience. Make it because the references weren't as good. Whatever the true reason is, we don't want to be untruthful, but you want to make sure you're documenting a reason other than a potential disability discrimination claim as to why you're choosing not to hire that individual. And then the last one we've got here is it talks about an employer who's reopened their office. The employee is in high risk. They can't come into the office. The question is, can you require them to come into the office? And if they don't come into the office, do you have to pay them? And do they have to use their paid time off to get leave?
So there is an executive order. It's 107. This came out very early on during the pandemic in March. And it says that employers are required to allow employees to telework or to work from home whenever it's practicable. And it's important to know that if there's any ability to allow that employee to work from home, requiring them to come into the office would be forbidden under that executive order. More importantly, Ursula mentioned the ADA, the Americans with Disabilities Act, and the law against discrimination. If you have a high-risk employee and that employee legitimately cannot go out into the workplace, cannot be exposed to COVID-19, say they have cancer or some other illness that makes it difficult for them to contract COVID and have severe symptoms, to the extent that they can be reasonably accommodated under the ADA and under the law against discrimination, you as the employer are required to do so. And that requires an interactive process, right? You may say to that employee, you need to come into the workplace because it's an essential part of your job. And that employee may say to you, but I can't, I'm at very high risk, I'm uncomfortable doing that. Then you have to assess whether you as the employer have some ability to make some reasonable accommodation. Are you sure that that employee cannot work from home? Are you absolutely sure there's no way to do that? And if there's not, and that employee has a serious health risk, they may qualify, in addition to using their paid time off, their paid sick time, their PTO, they may qualify for leave under the Family and Medical Leave Act, which is unpaid. And, as we noted, the employee would get 12 weeks of leave. But that's only if no option is available from the employer for that employee to continue working otherwise. It's very important to have that conversation and to make sure that it's really a necessity to have them come in before you deny that option, the teleworking option.
And it's very case specific to the title, right? If an employee has to stand at a press operator and they have to physically be there, then of course, if they're not in, then you don't have to pay them, right? They're not able to meet their job responsibilities. However, if it's somebody who's in sales and everyone else who's a salesman can work remotely, why can't this person? So you want to be careful with that. And then the other question in here is, do they have to use their time to get paid, their accrued time off? So that chart, that New Jersey scenario of COVID that we looked at earlier in the presentation, if you look at it, number 8 on that chart is employer permitted to be open, but workers afraid of gathering in a group and refuses to work. And it specifically says there, the only available options for that person are New Jersey earned sick leave and perhaps even temporary disability. And again, that's going to be an option for them to file under. But the next question also here on the same arena is, can accrued sick leave be used while sick with COVID, or is an employer required to pay for the 2 weeks without using the accrued sick leave? Nicole, I don't know if you touched on the tax benefits or how that works with the paid sick leave.
No, I didn't. And if you could go into that, that would be great. But I should mention, though, that with regard to the Emergency Paid Sick Leave Act and the expanded FMLA leave, you cannot first require an employee to take their paid sick leave. So they may do so. They may opt to do so and say, listen, I want to use my PTO first. But they have to be able to use their emergency leave under the FERCA if they actually qualify to do so.
And so I'm not an accountant, so I don't pretend to understand this fully. But when you are paying your employees under FERCA for the 2 weeks or paid sick or the full 10 weeks with the maxes, where we saw the maximum set forth, you're going to get a tax credit for that you should make sure you document every single dollar paid under FERCA. And at the end of the year, or make sure you talk to your accountant now, because you'll get a tax credit for those payments. So yes, you need to pay them, but somehow it's going to work out towards the end. So you want to make sure you're talking to your accountant about that.
Right. And it's not full reimbursement, but it's something. So it really has to be documented in payroll.
Excellent. Great. Next slide.
Yeah, I think we can go on to the next slide.
Okay.
All right. So an issue that's come up very frequently for us and really for a lot of employers probably is employees having anxiety. So what do you do when an employee is afraid to come to work? They say, I'm petrified of getting COVID-19. I can't come to the office. I'm just too scared. I can't handle it. Can you discipline an employee in that scenario? The answer is generally yes. However, you have to be mindful of the laws that we've discussed today, the FERCA, the Family and Medical Leave Act, and most importantly, the Americans with Disabilities Act, because sometimes it's not just anxiety and a refusal to come to work, but it can actually be a medical diagnosis of severe anxiety. And that employee, if they legitimately cannot function in the workplace because their anxiety is that severe, and they have the medical documentation needed to take FMLA leave, that is a legitimate reason for taking that leave, assuming they have the required documentation. And you, as the employer, we just talked about this, the working from home option, the teleworking option, you as the employer, if they come to you and you really think that this may be a medical issue, mental health issue, you have the ability, or not the ability, the requirement rather, to engage in the interactive process with that employee and see if there's any accommodation you can make so that they can function, can continue to fulfill the essential duties of their job, and to do so from home. So generally, yeah, if an employee just says to you, I'm afraid, I don't want to come to work, that warrants discipline if they simply refuse to report to work and refuse to do their job. But you really want to carefully look at this issue. And if they come to you with medical documentation, they have a doctor's note, something along those lines, then you really need to look into these laws and make sure that you're not disciplining an employee who qualifies for some other type of leave for a medical reason.
And before we move on, I know under the Q&A, there's some more questions here about teleworking and COVID and how we deal with that. So one of the things a lot of our employers have done is created what's something called a pandemic response policy. Right. And what that does is essentially set out how it's going to work for your company. How are you going to bring people back? When? What are the PPE requirements? And perhaps most importantly, what are your monitoring procedures for your company, right? So typically it's CDC. And you know what? The CDC website and the CDC symptoms of COVID are changing on a weekly basis now, it seems like, if not more often. So if you have questions, or if you want to make sure that you're in compliance, you want to have some sort of policy in place that says, we're going to comply with the CDC. Maybe you're taking temperatures. Maybe you're asking employees to make sure they haven't traveled, right? Or now it's that they don't have any of the symptoms. Symptoms have changed since March, right? But you want to make sure whatever you're doing it consistently. One of the questions here is, can we mandate a COVID test if someone doesn't feel well and not let them return until they get a negative test? So again, the lawyer answer, right, is it depends. If you have a policy that says anyone who displays symptoms of COVID must have a negative test before they return to the workplace, a year ago, I would have told you never, ever, ever. But given COVID and this public health emergency, as long as you have that policy and you are consistently applying it, you can probably do that. Have the policy, make sure you're providing the leave that's required under the law, and you can do that. The question is also, next one is, do you have to provide stipends for things like internet devices for employees who are teleworking? Again, in that pandemic response policy, you can have, pandemic response policy, you have within there what you need to provide. And there's nothing that says you have to provide internet. There's nothing that says you need to provide printers and paper. However, practically speaking, that is something that a lot of employers are providing in order to make their employees efficient. You have to decide what your teleworking is going to look like for now, which again is probably a new policy ideally, because then you have it written down to show that when Sue asked for a printer, we said no to her. So therefore, we also said no to Dave, right? To show you're consistently enforcing your policies and not treating anyone differently based upon any of those protected classes.
Ursula, but before we go, how do you who writes the policy? What's legally appropriate for me to, can I change the policy? I'm the CEO of the company. I'm 100% owner. Can I change it at a whim?
You know what's awesome about employee handbooks and policies? They can be changed at any time for any reason without prior notice to your employees, right? And that's what we put at the beginning of all of our employee handbooks. And I understand that people can't spend thousands of dollars and it's crazy right now and things are moving. So just make it a piece of paper, provide it to your employees, stick it in a binder, make sure everyone knows about it. That'll suffice for now. Eventually, of course, you want to put it together in a nice binder and make sure everyone gets it. You want to make sure people sign off on it, but you have the ability to change your policies immediately and at any time. Again, don't do it because you've just had a race discrimination claim, so now you're implementing it, right? You want to be careful on how you do it, but absolutely, you can create a pandemic response policy. You know, it's something we do often. I'm sure you can go online and get something. At least use it so you can show that you've got something that you're consistently enforcing in your workplace.
Yeah, we write those for our clients all the time. And one thing we tell them is, especially now, because everything's changing rapidly, is when they issue that pandemic response policy, it's often remote now. So it goes out via email and you need some response from the employee indicating that they've read it. And even better, as Ursula mentioned, you have a written acknowledgement form saying, I've read the pandemic response policy, I understand the terms of it, and have the employee date it. And you have the version at the bottom so that there's a clear documentation that they received it and understood it. And then when they come into work and they refuse to wear a mask, you clearly advise them that that was a requirement. And then you can move forward with the discipline even more cleanly because you put the employee on notice.
Wonderful.
And I know a lot of people are hesitant to do employee handbooks. So two things that are super important is, if you do it, make sure you put in there bold letters, underlined, highlighted at the beginning and at the end, that it's still an at-will relationship, right? Anytime you do a policy, you want to make sure you're clear in there that that doesn't in any way affect the fact that any employee can be terminated at any reason or for no reason at any time, just like that employee can leave at any time. You want to make sure that at-will status is always maintained.
Right.
That's good. Is this the last slide?
No, I think we can move forward, but I think we have two more.
Two more? Okay.
Right. Another question we get often from employer clients is, can an employee be disciplined if they refuse necessary work travel because they're afraid of contracting COVID-19? And the answer to this is, generally speaking, yes. If travel is an essential part of that employee's job duty, and we always say, when you hire someone, have a job description and you indicate that travel is required in there, right? It's always important to list the functions of an employee's job in the job description. But if travel is required, if it's really necessary and that employee refuses to do it, they can be disciplined. But in this situation, you want to ask yourself as the employer, is it really, really necessary right now? Is it really critical for an employee to hop on a plane and go to an in-person meeting in Florida? Or could they simply sit in the conference room in New Jersey or from their home and do something via Zoom? Can they have a virtual meeting? Do they really need to go somewhere? And that it's really important to take employee concerns seriously in this context and to consider alternatives, right? You want to postpone travel if it's not necessary. And you want to have employees participate remotely to the extent they can, because your goal is to keep them safe so that they can continue working. First, it's the right thing to do. But second, these executive orders, the law right now and CDC guidance requires employers to be extra cautious. So travel should only happen if it's critical for that employee to go somewhere in person. Otherwise, you need to work with that employee if, especially if they're high risk and they, air travel or traveling to a state that's on this high risk list is something that would pose a serious danger to them. If a virtual experience, meeting, whatever it is possible, you need to allow that in that scenario, or you could be open to an ADA claim or LAD claim in the event that you require that employee to travel, or you discipline them for failing to do so. One previous. Yeah, and another question we get often from employer clients is, can an employee actually be disciplined for their refusal, failure to adhere to a policy that requires PPE? The answer is absolutely yes. Right now, as we mentioned, Executive Order 192 requires employers to provide masks, and it requires everyone who reports to any work site to wear a mask. So if an employee comes in, especially if you have a pandemic response policy where you say you have to wear a mask, and that employee just says, you know what, I don't feel like doing this, I don't want to, it's uncomfortable, you can absolutely discipline them for violating the executive order, for violating your workplace policies, your pandemic response policy. There are certain exceptions, right? So if a mask interferes with the employee's job in some way, or if it creates an occupational hazard, obviously it can't be required of an employee. In that scenario, you want to try to sequester that employee from other employees, right? You don't want to have people within 6 feet of each other. So if they can't wear masks for their job for whatever reason, that they're violating that social distancing protocol that is required in Executive Order 192. But if the mask genuinely interferes with the job or creates some type of hazard, that's an exception. It's also an exception if the mask exacerbates an existing medical condition, right? So this falls under the ADA. And you as the employer in that scenario, when an employee says, listen, I cannot wear a mask because of XYZ medical reason, you then have a requirement under the ADA and the law against discrimination to try to make a reasonable accommodation for that employee to the extent you can. You're not going to want them in your office because you will not want them to expose other employees to COVID-19. It's very high risk to not wear a mask, as we all know, but you need to engage in that interactive process with them and determine, can we have this employee work remotely, or is there something else we can do to accommodate this person for now? And that's the process that, that interactive process, anytime an employee has a concern related to their health and COVID-19, that's a process that you as the employer need to undertake. And it's really important, as Ursula's mentioned, and we always say this, document, 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 right? If an employee comes to you and that such an accommodation is not possible, you need to have a basis for why you deny that accommodation.
And one of the things that we see coming down the pike is, now that we have vaccines, mandating vaccines. Mandating that, and now what's the limitation on that? If I have a small business, can I mandate that everybody has to take the vaccine before they can come to work?
This is a really unclear issue right now, and it's the subject of much discussion. My personal opinion at this point is absolutely not. You're requiring an employee to make a personal health decision that, it may be personal to them, may not be healthy for them for whatever reason. You can require them, however, to take the safety measures that are mandated in the executive order and in your pandemic response policy. So at this point, I wouldn't say everybody needs to get a COVID-19 vaccine, but
Right.
yes, you make them wear a mask, you make them social distance, everybody has to wash their hands, the workspace is clean. And we hope that everybody gets the COVID-19 vaccine, but mandating it could be problematic, and it could be discriminatory if someone is not able to take it for a health reason and then they're disciplined because of their failure to get the vaccine. So I would be really careful with that right now, unless there's some type of law mandating it, which has been discussed. It has not been passed yet. So I would say no right now, no mandate.
And before we end, so we just have so this is your number at the bottom of the screen. I don't know if everybody can see it, 973-729-1880.
That's
and
right.
The website is lcrlaw.com. So if you have, this is really great information, and it's so complex. And it's getting more, it seems like it's getting more complex every week.
It is.
So, but you guys, you're doing a great job of explaining it. Anything else? Is this, I'll stop sharing the screen.
Because there was just a question there about accrued leave. Someone asked if accrued leave ends at the end of the year. And again, the answer is it depends. If someone has, paid sick leave, New Jersey paid sick leave, that 1 hour for every 30 up to a maximum of 40 hours per year. You're going to have a policy and you're either going to carry it over or you can offer to pay half or all of it. Vacation pay is not required in the state of New Jersey. Holiday pay is not required in the state of New Jersey as it stands now for you as private employers. So you have to have a policy. Your policy should say whether you pay it or not at the end of the year, whether you carry it over. And it should also say what happens at time of termination. I got to tell you, the worst thing I have to do is have an employer who has a policy who says we're going to pay you your vacation and holidays at the end of the year if you haven't used them. At termination. And then the employee is awful. They have a terrible termination. They terminate, and then they have to pay him $5,000, right? So you want to make sure whatever it says in your policy that employee has to leave in good standing. So at least if something terrible happens, you're not having to pay them out these accrued benefits on top of everything else. So again, policies, documentation even affects your accrual and how you're going to pay out time at the end of the year.
Right. Any other questions?
I think I hit them all. I tried to.
About the chat and the Q&A?
Yep, I think I got them.
Yeah, I couldn't be. I want to go back to the one, and I think you answered this. And I'm spending so much on printing costs. And now I'm saving money by not going to the office. I work in Madison, live in New Brunswick, but and so there really is nothing that employees can do to get reimbursed for those costs unless it's in the manual, unless it's in your company's manual. Is that correct?
Yeah, it's going to be case by case specific, right? But if you are working from home remotely and that's how you're doing it, you can ask your employer and explain that it's required. And if you don't have it, what are they going to do? And are you meeting the essential functions? So it's tough. That's why I think a lot of employers are going to have these telecommuting policies to make it clear moving forward.
Wonderful. Well, I think we're at time. You covered a lot of information, and Nicole and Ursula, I want to thank you very much. Our Family Business Friday, and so we're taping this, and it will be on our YouTube channel, the Rothman Institute, and we gave their information. So please reach out to them. They're a great firm, and obviously very, very knowledgeable. And we will have you back hopefully, because 2021 is going to have a whole new set of rules.
Good luck, everybody.
Good luck. Thank you for having us.
So take care, everybody. Have a great weekend. Bye-bye.
Thank you,
everybody.
See you next week.
Bye. Thanks.